Hello, it's Alan White, your trainer for the fourth module of the AMCTO HR Law program, which deals with human rights and the AODA. This module will consist of an overview of the Human Rights Code and the Accessibility for Ontarians with Disabilities Act, commonly referred to as the AODA. When interpreting the code or deciding what action to take in a specific circumstance, employers should always be guided by the fundamental principles of the code, which are, first, promoting the dignity and worth of every person; secondly, providing understanding and mutual respect for disabled and other vulnerable people in society; and thirdly, providing equal opportunity to those same people to participate in and contribute fully to the community and, in the employment context, the workplace. The Canadian Charter of Rights and Freedoms, which I'll refer to as the Charter, is a constitutional document. It is described as the supreme law in Canada because it can be used in the courts to challenge or strike down unconstitutional laws or government practices. The Charter guarantees equal rights and treatment based on a number of grounds, including race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. It's important to note that the Charter only applies to the acts and conduct of government and does not apply to the acts of and conduct between individuals. By comparison, the Ontario Human Rights Code applies to both private and public sectors, as well as to conduct between individuals within the listed social areas. More about that later. Despite these differences, some of the general principles used to interpret the Charter can also be used in interpreting the Code. The next few slides are going to focus on the Human Rights Code, which I'll refer to as the Code. The Supreme Court of Canada has said that human rights legislation such as the Code is not like other regular laws. It should not be treated the same as other pieces of provincial legislation because it is almost as important and authoritative as the Constitution. Often it is said that the Code is quasi-constitutional. This means that you must comply with the Code before and above all other laws, unless there is a specific exception. In a 1982 case, the Supreme Court of Canada said, "The Code is a fundamental law intended to supersede all other legislation, except where a contrary intention is clearly and unequivocally expressed by the legislature." An example of how this works will be useful. The Workplace Safety and Insurance Act, which is a provincial piece of legislation, imposes a duty on employers with more than 20 employees to re-employ a worker if that worker has worked for the employer for a year before their injury. However, under the Code, all employers have a duty to accommodate to the point of undue hardship, no matter how many employees they have or how long the employees have worked there. In fact, some of the Human Rights Code cases have involved employees who have very short service, as short as 10 days. So it can be seen that if you comply as the employer with the lesser requirements of the Workplace Safety Insurance Act, you may not be complying with the requirements of the Code. The Code provides for equal rights and opportunities without discrimination in 5 social areas. The first is employment, and of course that is the social area that is most pertinent to this course. The other social areas are housing, contracts, goods, services, and facilities, and membership in vocational associations and trade unions. In Ontario, about 3/4 of all human rights claims or applications arise out of the social area of employment. The concept of employment has been interpreted very broadly under the Code. In fact, it's been extended to include independent contractors and volunteers. In those cases where there is an issue about whether someone is an independent contractor or an employee, it must be borne in mind that there is a social area of contract so that it may not matter whether or not the characterization is that of an employee or that of an independent contractor. It should be noted that human rights complaints can be filed against employers, contractors, unions, and members of boards of directors. Also, employers and unions have a joint duty to ensure that workplaces are free of discrimination and harassment. The prohibition against discrimination in employment covers the entire job cycle and includes applying for the job, recruitment, training, transfers, promotions, terms of apprenticeship, dismissal, and layoff. It also covers rate of pay, overtime, hours of work, holidays, benefits, shift work, discipline, and performance evaluation. In fact, it covers everything from the absolute beginning of the employment relationship, perhaps a job ad, right through to the end, be that by retirement, termination, or otherwise. Section 5, subsection 1 of the Code is the main section that prohibits discrimination in employment. A couple of things to note about Section 5, sub 1. The first is the phrase "because of," that establishes the need for causation between the act complained of and the 16 prohibited grounds of discrimination that are listed in the section. Secondly, some of the phrases that are used to describe the prohibited grounds are defined in a certain way or have been interpreted in a certain way. The first of those is the phrase "record of offenses." That is defined as a conviction for a federal offense which has been pardoned, and it's also defined in terms of a provincial offense or conviction. In other words, it is possible theoretically to discriminate on the basis of an unpardoned federal conviction. The phrases gender identity and gender expression, which were added into the Code in 2012, are undefined but generally are intended to deal with transgender and transsexual individuals. Age is defined as an age that is over the age of 18 years. Family status is defined as the status of being in a parent and child relationship, and that has led to some case law about the extent to which employers must accommodate parents who have serious child care problems. Disability is a large definition and a large subject which will be dealt with in the accommodation module of this program. In addition to prohibiting discrimination, the Code also prohibits harassment. Section 5, subsection 2 of the Code prohibits harassment on the basis of any of the 16 prohibited grounds that we just reviewed. Harassment is defined in the Code as engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. Vexatious is generally defined and understood to mean annoying or distressing. The use of the phrase "ought reasonably to be known" implies an objective standard, meaning that someone's conduct may be judged by a third party, such as a court or a tribunal, in terms of all of the circumstances, leading to a conclusion as to whether they ought to have known that their conduct was unwelcome. Take a look at this scenario about Johnny, who is an avid Toronto Maple Leafs fan, and his situation at the office. Do you think he's being discriminated against contrary to the Code? In fact, he's not, because allegiance to one hockey team or another is not caught by any of the 16 prohibited grounds in Section 5 of the Code. Take a look at this next scenario about Peggy, who lost her position while she was away from work on pregnancy leave. Do you think that is potentially discrimination under the Code? This scenario is taken from a 2012 Human Rights Tribunal of Ontario case. The finding in the case was that the termination was not discriminatory. The employer was able to demonstrate to the tribunal's satisfaction that the reason for the termination was a loss of business, necessitating the elimination of Peggy's position. In a human rights case at the tribunal, the burden is ultimately on the applicant to demonstrate that the code has been violated, and Peggy wasn't able to do that in this case. Take a look at these two YouTube clips and see if you think there is discrimination that is prohibited by the code. The first clip involves someone putting someone else's office supplies in Jell-O. There's nothing in this scenario that suggests a prohibited ground under the code, although this conduct could be considered to be a form of personal harassment or potentially Bill 168 harassment, which we will be reviewing in the module on the Occupational Health and Safety Act. The second clip probably does involve code discrimination, either based on gender or on sexual harassment. One incident of harassment can constitute harassment under the code, although it is usually more serious than what is seen in this clip. The human rights system in the province of Ontario was extensively changed in 2008. Under the old system, if a person thought they had a complaint, they would go to a Human Rights Commission office, sit down with an employee of the commission, and that commission might give them some advice about whether or not they should proceed with the complaint. If it was proceeded with, then the commission would assist the complainant in drafting the complaint. The complaint would be served on the respondent, and the commission would provide mediation services. If the complaint was not settled at the mediation stage, then the commission would investigate the complaint. Ultimately, the commission might end up referring the complaint to the tribunal, which at that time was a small body that heard very few cases per year. Under the new system, the big player is the Human Rights Tribunal of Ontario, which I'll refer to as the tribunal. Applications, as they're now called, are filed with the tribunal. The tribunal manages the paperwork between the applicant and the respondent. The tribunal provides mediation services, case management, and ultimately hears and decides the case. The Human Rights Commission still exists, but in a much reduced capacity, mainly focused on public education. There's also the Human Rights Legal Support Center, which provides free advocacy services to applicants. So to start an application, the applicant has to fill out an application, which is a fairly detailed form and can be accessed online. There is some internal vetting at the tribunal to ensure that the application engages one of the 5 social areas of the code and that it pertains to one of the prohibited grounds of discrimination. If the application is found by the tribunal to contain a starting or prima facie case, then the application document is served on the respondent. The respondent has 35 calendar days to prepare a written response, which is filed with the tribunal. The applicant has an optional right to file a document called a reply, which must be limited to responding to new issues and items that were first raised in the response. Together, these documents are referred to as the pleadings. This slide contains a schematic representation of the stages through which an application may progress. It is possible that an application will be dismissed at an early stage through the summary hearing process or otherwise. If it is not so dismissed, then it proceeds to mediation, but only if both parties have agreed to mediation. At the mediation, a vice chair will serve as mediator and will do his or her best to resolve the case to the mutual satisfaction of the parties. If the case is settled, the process stops there. However, if it is not settled, then it proceeds through various other stages, including document production, preparation of witness statements, and the like. The tribunal will, at a certain stage, case manage the case so as to produce an expeditious but fair and just hearing. If a hearing does take place, there are 2 potential outcomes. The first is that the application is unsuccessful, in which case it will be dismissed. For example, as I mentioned previously, the applicant bears the onus of proof that a violation of the code took place, although the onus of explanation may shift at some point in the case to the respondent to explain why its decision or conduct was not discriminatory or harassing. The overall burden of proof remains with the applicant. The other scenario is that there is a finding that the code was violated, in which case the tribunal will turn its consideration to the question of remedy. The tribunal has a broad discretion to grant remedies, but there are three usual categories in employment cases. The first category is damages for compensation for injury to dignity, feelings, and self-respect. These damages are sometimes referred to as general damages. Damages can also be granted for actual losses. For example, if someone was terminated and suffered a loss of income as a result, an order could be made by the tribunal for the respondent to pay damages equivalent to that loss. These damages are sometimes referred to as special damages. Thirdly, the tribunal has the ability to grant what are called public interest remedies. These typically involve an order for the respondent or its senior managers to undergo training in human rights, to develop or revise policies related to human rights issues, and the like. If a respondent receives an order from the tribunal that it does not like or agree with, there essentially is no right of appeal. There is the right to request reconsideration of the order in question, but the right of reconsideration is very circumscribed, and there is a very high threshold to get over, which very few people succeed in doing so. The other process is judicial review, which is a court application alleging that the tribunal made a fundamental error in either the way it treated the evidence or treated the law. Again, this is a very high threshold, and very few judicial review applications are successful in relation to human rights tribunal cases. The AODA was passed in 2005 and is literally world-leading legislation. The thrust of the AODA is not enforcement and punitive measures in order to promote accessibility. Rather, it is proactive and requires organizations to take a forward-looking perspective on their organizations and how their organizations can promote accessibility in all respects of society and the workplace. The Act is written at a fairly high level, and the guts of the legislation are found in the 5 regulations or standards. As of the fall of 2012, 4 standards are in effect. The 5th standard, the Built Environment Standard, which relates to the physical environment, is in draft form and will ultimately be enacted through the Building Code Act. The Customer Service Standard has been in effect since 2010, and the Information and Communication, Employment and Transportation Standards were implemented through the Integrated Standards Regulation, which came into force in June of 2011. Given the focus of this program on human resources law, the ensuing discussion will focus on the employment standard only. The proportion of the Ontario population that is disabled in one way or another is on the rise. Currently, 1 in 7 people in Ontario have a disability, but by 2036, that's expected to rise to 1 in 5. From a customer service perspective, it is simply good business to make your organization more user-friendly for those with disabilities. Now I'm going to walk you through the employment standards specific requirements. Some of these requirements codify what's been going on in the HR world for a while. Some of them describe best practices which are now required under the regulation, and some of them deal with issues that we in the HR world have not really thought about in relation to accessibility. The first group of requirements pertain to the recruitment process. Employers are obligated to advise its employees as well as the public about the availability of accommodation for applicants with disabilities in its recruitment processes. This is easily accomplished by including language to that effect in job ads and other places where job opportunities are advertised. Secondly, the employer is required to advise job applicants of the availability of accommodation in the selection process. Thirdly, the employer is required to notify the successful applicant of its policies for accommodating employees with disabilities. All three of these items are relatively easily accomplished. The next standard relates to the development and provision of individualized workplace emergency information. If the employer is aware of an employee who requires accommodation, then this standard requires the development and provision of specific information specific to that employee about how they will be evacuated or otherwise made safe in the event of a workplace emergency. The requirement is to work in cooperation with the employee who requires accommodation, and also to keep the plan updated in the event that the employee moves to a different location in the organization, the employee's accommodation needs change or are reviewed, and when the employer reviews its general emergency response plan. This requirement is in effect as of January 1st, 2012. A further standard requires that employers take into account its employees' accommodation needs in relation to three areas: performance management, career development, and redeployment processes. Performance management is defined as activities relating to assessing and improving employee performance, productivity, and effectiveness with the goal of facilitating employee success. Career development and advancement is defined as providing additional responsibilities within an employee's current position and the movement of an employee from one job to another in an organization that may be higher in pay, provide greater responsibility, or be at a higher level in the organization, or any combination of them. And for both additional responsibilities and employment movement is usually based on merit or seniority, or a combination of them. Redeployment is defined as the reassignment of employees to other departments or jobs within the organization as an alternative to layoff when a particular job or department has been eliminated by the organization. These are areas which traditionally have not involved much consideration in relation to accessibility, but are now part of the employment standard. The next standards relate to documented individual accommodation plans for employees with disabilities and also the return to work process. These items would be in the category of best practices, which have now been codified in the employment standard. The factors listed in the standard relating to individual accommodation plans are the following. 1. The manner in which an employee requesting accommodation can participate in the development of the individual accommodation plan. It should be noted that the participation of the disabled employee is very important, and that will be discussed more in the accommodation module. Secondly, the means by which the employee is assessed on an individual basis. So once again, there shouldn't be any stereotyping, but the person with the disability and the need for accommodation should be addressed as an individual. Thirdly, the manner in which the employer can request an evaluation by an outside medical or other expert at the employer's expense to assist the employer in determining if accommodation can be achieved, and if so, how accommodation can be achieved. So as we discuss in the attendance and disability management module, the securing of medical information is a sensitive process because of the privacy considerations. So this standard is saying deal with the issue up front. Fourthly, the manner in which an employee can request the participation of a representative from their bargaining agent, where the employee is represented by a bargaining agent, or other representative from the workplace where the employee is not represented by a bargaining agent in the development of the accommodation plan. It's not every employee that wants to have a bargaining unit representative or anyone else involved because of the privacy issues that can be invoked in some accommodation processes. Fifthly, the steps taken to protect the privacy of the employee's personal information. 6, the frequency with which the individual accommodation plan will be reviewed and updated and the manner in which that will be done. The reviewing of accommodation plans is critical to ensuring their validity and applicability. 7th, if an individual accommodation plan is denied, the manner in which the reasons for the denial will be provided to the employee. 8, the means of providing the individual accommodation plan in a format that takes into account the employee's accessibility needs due to disability. The return to work standard simply requires that employers are to develop and have in place a return to work process for its employees and to have documentation in place pertaining to that process. The next standard requires employers to inform its employees of policies used to support its employees with disability, including policies on the provision of job accommodations that take into account an employee's accessibility needs due to disability. This is to be provided to new employees as soon as possible after joining the organization, and this requirement also applies to updating information if there is a change in the policies in question. The next standard requires the employer, where an employee with a disability requests it, to consult with the employee regarding the provision of accessible formats and communication supports relating to information that is needed in order to perform the employee's job, and also information that is generally available to employees in the workplace. This can either occur within an established accommodation process or as the need arises. The supports that may end up being put in place can be as simple as providing the employee with information in large print or in plain language. The overall time frame for the implementation of all AODA standards and requirements is the year 2025. However, the standards that we've reviewed here are generally applicable to large designated public sector organizations, which include municipalities, and large means that the organization has 50 or more employees. Those organizations are to have the employment standards that we've reviewed in place by January 1st, 2014. For small municipalities, meaning those municipalities with less than 50 employees, the deadline is January 1st, 2015. As mentioned, the emergency workplace information, which was previously discussed, was to be in place by January 1st, 2012.